Let me now introduce our eminent contributors today. First of all, as you have some lovely information and some lovely photographs of our two legal minds, but let me just talk a little bit about, first of all, Emeritus Professor Rick Sarre. As you will see from your information sheet, he's an Emeritus Professor of Law and Criminal Justice and an Adjunct Professor at the University of South Australia. He was a former Dean of Law at the university, and he was also, for a goodly number of years, the chair of the university's academic board. He was most effective and most engaging as the chair of that board. And you'll get a sense, perhaps, when you hear from him today, how well he might have run that august body. He's a past president of the Australian and New Zealand Society of Criminology and also a fellow of that body. His extensive qualifications read like a tour around the world, in effect, with a Bachelor of Arts in Laws from University of Adelaide, then a Doctorate of Legal Science at the University of Canberra, a Master of Arts in Criminology from the University of Toronto, and an honorary doctorate from Umeå University in Sweden. And as you might imagine, much of his career was spent in lecturing and teaching in various countries around the world, including, of course, as you might imagine, the US, Hong Kong, Sweden, and, of course, here at the University of South Australia. Rick's a regular media commentator, and for over 20 years, in earlier times, he appeared he was regularly on radio, ABC Radio Adelaide, often called to write articles in the Advertiser. And for those of you who've subscribed to The Conversation, you will know that Rick writes very frequently for The Conversation, research-based articles on legal matters, and for the discerning reader, of course. And he writes very frequently, and I must confess I enjoy reading those very much. His expertise, of course, is on matters such as criminology, crime prevention, policing, security, cybercrime, and surveillance. Let me now then move to introduce you to Professor Eileen Webb. Eileen is a Professor of Law and Ageing at the university. Her areas of expertise do include ageing and law, or elder law, and the human rights of older people. And her research has examined older people's rights to housing and housing security, amongst other things. I would like to add some extra information for you, not on your information sheet, to let you know that in 2020, Eileen was awarded the Adam Sutton Crime Prevention Award, given by the Australian and New Zealand Society of Criminology. It was based on work that she and her team did on the prevalence and characteristics of elder abuse in the state of Queensland. In early August, probably in about 10 days, I think, Eileen, a seminal work is going to come out, edited by Eileen and a co-editor, and contributed to by her. It's called The Age-Friendly Lens. It's a book that's coming out in early August. It's a series, as I understand it, of essays and case studies. And to read a little blurb about it, because I think you'll be interested to read this. The book engages with the concepts of age-friendly environments, and it serves as a catalyst to stimulate research, policy, and public interest in the physical, social, and regulatory environments in which we age, and the consequent impact on health and well-being. She's written extensively, too, on the security of tenure for older people, particularly how the operation of existing laws may make older people susceptible to financial exploitation. I could go on about both of our eminent speakers, but I'll restrain myself, but simply to say I look forward to Rick Sarre in conversation with Eileen Webb. Let's join them in welcoming them. Thank you.
Do you want to flick that first slide up? There we go. Well, I'll just do a little test here with the sound system. It sounds pretty good to me. And I'm getting lots of nods up the back. What Ruth didn't say, thank you, Ruth, for those very kind words. What she didn't say was, I like telling jokes. A couple of quick ones. An Englishman and a Scotsman and an Irishman walked into a bar and the bartender said, what is this, some sort of joke? And then the next day, a priest, an imam and a rabbit went into the bar and the barman said, I think there's been a typo. Okay, let's start. What we're going to be doing, we've got 2 40-minute sessions and we're going to have Eileen and me in conversation, although when Eileen and I were talking about this, I realised that I'm going to ask the questions, she's going to answer them, and then I add value. That's the plan. We've decided, and we worked through a bunch of questions yesterday, so there's no tricky questions here. Eileen has given some thought to all of these, and these are all a bit of Dorothy Dix's. And you're going to say, Rick, you're just reading out the questions. What are you doing here? After all those nice things Ruth said about you. I am going to add value if I think there's some opportunity there for me, however. The way we're going to do it is I'll be asking Eileen to address 4 questions for 30 minutes and she'll deal with those topics. Then 10 minutes of questions. Then we have afternoon tea, which is always my highlight. Then we come back in here and another 4 topics over the next 30 minutes and then 10 minutes of questions at the end. So it's very structured. Here are the topics so you know what's coming, so you don't ask the wrong questions, otherwise you'll be thrown out after the first 30 minutes. We're going to talk a little bit about the context in which this entire topic sits, then something about elder financial abuse, something about other abuse and neglect, which Ruth just mentioned has been Eileen's focus in the last little while, and the book is coming out, and then something about contracts and consumer rights. And I should say, in this very lecture theatre, I used to lecture on contract law, so I might add some value there. We'll then take the break, and after the break, the other 4 topics that we'll be addressing: housing, accommodation and care, including retirement villages. The number 6, living with family and what those pitfalls are. Something about the aged care system and how that fits in, what the government's doing. And finally, something about decision making and capacity. All the while, Eileen will be showing a slide or 2 on the board behind you to give you some dot points and to act as an aide-memoire for her. So that's our program. So here we go with topic number 1. And the context. So here's my question. Eileen, the law is concerned with about eliminating ageism, but the legal scene is beset with disconnects, such as the distinction between federal and state legislation, oppositional political games, important but somewhat unenforceable international obligations, and oft-times the conflicting findings and recommendations of royal commissions and other inquiries. How do you get your head around all of this and remain sane?
Indeed, and maybe it's a question of are we all still, am I still sane after the last few years? But basically, when we're looking at the legal framework, I think it's quite a useful exercise initially, because many of the topics which come up this afternoon will be able to actually put it within that context, and we can sort of see, well, why isn't that happening here, and why isn't that happening here? So hopefully this will make it just a little bit, put it in a bit more perspective. So basically, if we start thinking about the legal framework as a bit of a triangle, and at the top we've got various international conventions, which I'll very briefly discuss in a moment. But really, where the focus is going to be today, of course, is the relationship between Commonwealth laws. So, for example, we're all familiar with the Aged Care Act, which is Commonwealth legislation, as against state or territory legislation. So we'll also be talking today about the Retirement Villages Act, or we may be talking about the Guardianship and Administration Act, etc. And which are big pieces of state legislation. So it's a bit of a jigsaw puzzle trying to figure out where we are. Rick, you did mention these international conventions. Just very briefly, basically, if we even start at the Universal Declaration of Human Rights, we've got the right to the highest attainable standard of living, right to social security, a right to an adequate standard of living, including food, house, clothing and shelter. Okay, so basically, we're trying to take these principles and also work them into the law. Now, there's a number of covenants which I won't have time today to take you through, but I'd just briefly like to mention 2 things which you might find interesting. Firstly, there is an existing covenant in relation to the rights of people with disabilities, and there is quite a bit of overlap, and in ageing in law, many of those covenants in the Convention in relation to disabilities can also impact on older people who are experiencing disabilities. The problem that we have with that, of course, is just because you're older doesn't mean that you have a disability, and therefore there is a huge hole in the operation of that particular convention. So what is happening at the moment, and you might find quite interesting, is that the United Nations is looking at introducing a convention on the rights of older people. And it's been going for 12 years now, so the progress has been quite slow. But there is another meeting in Geneva next month where hopefully the burners are going to get underneath it, and we're actually going to see some action on this. So it's actually a very exciting time at that level. Now, the problem, Rick, that, where do we get this link, if you like, between these wonderful international conventions and our domestic law? And some of the problems here, the problem here is that even if we ratify, Australia can ratify a convention, but it really won't have much impact, or it won't have any real impact until it's actually drawn down and legislated in Australian law. Okay, so we can be very clever with ourselves and ratify something and feel good about ourselves, but until we actually start putting it into the law, really, what are we doing? Okay.
Like the Age Discrimination Act.
Exactly. Do you want to have a chat, just mention that?
Just tell us something a bit about the Age Discrimination Act. Should we say something about that?
Yeah, please do.
You can't discriminate against a person on the basis of their age, and that would have emerged from us using the ratification of the human rights legislation of the covenants to put that into legislation.
Absolutely, yep. Yeah. And also too with this, with our new Aged Care Act, which you've heard about, one of the recommendations of the Royal Commission was a new rights-based aged care act that will draw on various international conventions as well in relation to introducing that legislation. But the problem, I suppose the biggest problem in relation to the legal side of it is that sometimes there's this disconnect between Commonwealth and state jurisdiction. So basically, the Commonwealth and states have particular powers in the Constitution, and some of them do overlap. In relation to the Commonwealth sphere, the one we're probably most familiar with is the Aged Care Act. But most of them, and I'll just show you this slide here. This is the chapter headings, if you like, from the Australian Law Reform Commission inquiry into elder abuse, which came down in 2017. But it's been the basis upon which we've got now the national plan in relation to elder abuse. But you just have a look down all those topics there, like the enduring appointments, family agreements, wills, guardianship and administration, etc. Most of those are state-based. So most of the law that we'll be talking about today is actually comes from the South Australian government rather than the federal government. Okay, so much, and actually, no, I won't go down that road, or we'll be here till afternoon tea. But so basically, a lot of the legislation we'll be looking at this afternoon is specifically in relation to South Australia. And just to finish up on that point, this is just a brief summary of the national plan in relation to elder abuse. We're going to go broader than elder abuse today, obviously, but it does tend to creep into the conversation in this area quite a bit. Now, you'll notice that it's 2019 to 2023, and we're now in July 2022, so they'll have to get their skates on with a few things, but there is a lot happening in this space at the moment. Does that answer your question?
It does. That's a perfect answer. Well done. Let me say that these slides can be available to anyone who wishes to have a copy of them later, because there's a lot of detail here. But it does segue nicely into this topic of elder abuse. We're going to look at elder financial abuse and then more broadly. Let me take this second topic then in our first 30 minutes. There are horrendous stories in the media about the manner in which financial abuse of older Australians occurs, especially where family, friends and so-called trusted advisors are concerned. We're going to tackle the other forms of abuse in the next question, but how can you advise concerning the phenomenon of financial abuse and how it could be avoided?
Okay. Financial abuse is extremely problematic, and actually I probably should say at the outset, until very recently, financial abuse was the most prevalent form of elder abuse. Interestingly, in the most recent stats that we've got, it's actually like psychological, emotional abuse has actually been exceeded financial abuse, but you can see with what we're going to discuss in a moment just how the two knit together. Okay, so basically, look, with financial abuse, the first thing with it is so very, very difficult to identify, because the thing is, one person's financial abuse might be another person's generosity to their family. Okay? So it can be very difficult to identify, first of all, and secondly, it can be the scope for financial abuse and the instances of it are incredibly broad. So just to mention in relation to how do we identify financial abuse, one of the actually, I'll give you an example, and Rick, you might like if you even come in on this, but I'll give you an example of some work that we did in Fremantle a number of years ago. Fremantle has a very high population of Italian and Portuguese families who came post-war, and they developed a lot of market gardens out the back of Fremantle. Now, what was always interesting about that was always sort of out in the sticks, but just recently it's become extremely valuable real estate. So these large tracts of land where the market gardens used to be are suddenly very desirable by developers running around Perth. So we had a situation where we had an elderly woman who had been widowed, and her oldest son was she was widowed, and she appointed her oldest son as the enduring power of attorney. So he could act on her behalf in relation to legal and financial matters. And what happened was basically the dad had died. And all of a sudden, Mum was picked up, taken to live with the family. She was put in this room at the back of the house, and the property was sold. And Mum, through the enduring power of attorney, and Mum didn't see any of the money. Now, why I'm sort of going on with this was, you're probably thinking that's just outrageous. That's just terrible. How could the son behave like that? But the thing is, to the mum, she was of the view that he was looking that the father had died, and now the son was stepping into the father's footsteps, and he was looking after her. She was living in the home, etc. So on one level, the legal service that I was working with was saying this looks like abuse, but on another level, the woman herself was of the view, like, no, she was horrified to think that this could possibly be the case. So it can be extremely difficult, number one. Number two, it can be very, very difficult to identify. Okay, so how did we know about that? We knew about it because a relative within the family was concerned about what had happened, and they actually went to... actually it was legal aid, and it was taken from there. And so it's very, very difficult to identify until you start seeing money coming out of accounts and that sort of thing, if people indeed pick up on it. And the third thing I'd say about it, it is so broad. It can involve real estate, like I've just mentioned. It can involve the abuse of an enduring power of attorney. So enduring power of attorney, taking money out of people's accounts and clearing them out. Selling the house, doing all sorts of things. It can be in the form of... I could talk about this all afternoon. I'll stop there, but the variety of it is enormous. Now, what can we do about it? We will be talking about this more generally in relation to how do we respond to this when we're looking at the other forms of abuse. Because again, if you do have a real instance of financial abuse, that's stealing. Okay, it's misappropriation. It's stealing, and therefore should that be a criminal offence, or should we go another route? So, sorry if I'm taking up too much time.
No, that's good.
there,
Let me put my contract law hat on and then my criminal law hat. One of the great dilemmas about using the criminal law to solve that is that typically the horse is already bolted and the criminal law is not going to have much of an effect, albeit perhaps a deterrent effect. Contractually, where there's been duress, which we could refer to, you can always set aside those contracts and return the parties to the position they were in prior to the contract or the sham contract being entered into. However, once third parties get involved, particularly in relation to real estate, you then have a problem in reversing all those matters and it gets rather messy, in which case the best advice is go and talk to a lawyer.
Yeah, you hate it when we say that, don't you? But
there's a couple of lawyers I can see in this room here. They'll identify themselves during the afternoon tea. Oh, that's a joke. I didn't mean to say that. Let's just morph then into this other aspect of abuse. That is, this more broadly aspects of abuse and neglect. What are we talking about here? What's its prevalence? What has the SA Adult Safeguarding Act done in order to protect us? And where are we currently with the debate over restraints of the elderly in terms of what force and psychotropic drugs might be used, particularly in nursing homes? So that's kind of the broader topic here. I'm sure, again, we could talk for another half an hour on that, but let's take us through some of those issues. Eileen?
Okay. Well, basically, we'll just start off with some stats, and I'm going to have to read them off here myself because my copy here is a little bit too small. But this is just some statistics from the Adult Safeguarding Unit's 2021 report, and I thought you might find them interesting because it just talks about who are the perpetrators, what is the type of abuse that we're looking at, and what are the and who is who is being abused. So basically, if we just sort of look with the perpetrators, adult sons and adult daughters are the most common perpetrators. We also are seeing, sadly, more grandchildren becoming involved in abuse. Now, in relation to the various types of abuse, these are the various percentages which are being recognised in South Australia. So you can see their emotional abuse is up there, 43%, and financial abuse sitting at 42%. That emotional abuse has actually been a big jump, and I think people are just recognising it more, and also rather than, say, for example, with financial abuse, focusing in on the financial aspect, looking at the fact that, well, this money may have been handed over not necessarily because the person wanted to, but because they felt under pressure from their family. We've got neglect, physical abuse at 17%. And I just want to briefly mention sexual abuse in relation to older people. This has actually become quite an issue, particularly in relation to aged care facilities. And it's really a topic which people just sort of tend to think, oh my God, this is terrible. The reason I'm bringing it up though is it is more prevalent. They estimate that around about 35 to 50 people are sexually assaulted in nursing homes per week across the country, which is I know it is incredible. And what is interesting about it is, and I will divert here a little bit, Rick, but just bear with me. What is quite interesting is they've recently introduced the serious incident reporting scheme under in relation to aged care. And initially, if a person was sexually assaulted but they had dementia, they thought the thinking was, well, we don't need to report it straight away, like within 24 hours, so it's a reportable incident immediately, because that person has dementia and they really wouldn't have known what was going on anyway. Okay? So that has been changed now after a lot of lobbying by Professor Catherine Barrett and her team at La Trobe. But I just thought I'd mention that because it's often forgotten, and it's again very hard to get hard statistics on it. But it's a very concerning development. And just in relation to the statistics on abuse, 67% female, 30% male tend to be abused, and of course the older you get, the more likely the abuse is to happen. So want me to just keep going with
Yes,
the
keep
ASU?
going with that. What's this
Okay.
ASU?
Well, alrighty. Well, the Adult Safeguarding Unit, look, this is a fantastic unit. It was an initiative of SA Health. They've got a great team of people in the Adult Safeguarding Unit. And what they do is safeguarding. So basically they are out there in the community, investigating and assisting in relation to older people who are experiencing abuse. Okay, so with this diagram, and I've got to shout out to my colleague Ben Livings who got this excellent diagram together. But basically, if you can make a report to the ASU, okay, and there's a 1-800 number. You can make a report. Now you can be anonymous. You don't have to give your name or details. The fact that you do report, if something isn't untoward, it's not going to bounce back on you. Okay, as long as you're making a report in good faith, that's enough. And then the ASU make a decision as to, they'll sort of say, well, look, do we invest? They'll investigate this, in the sense of they'll look behind it, and then they'll say, look, we think that this is okay, or no, this needs more investigation, and so on. And then it can move either to an investigation stage, or it can be referred to, for example, SAPOL or another agency, or they can work in tandem with that. Okay, so it is an excellent service, and the really good thing about adult safeguarding is it's like with the point Rick made before. Like with the criminal law, we tend to think these people should be punished, but it's such a blunt instrument, and families are such. It can be just so complex. I mean, one person's abuser might be another caregiver who's just simply worn out and at the end of their rope. Okay, so basically, what they do is they work with the families, and there's social workers, very, very experienced people who are trying to keep these families together. So it's a really, really excellent service, I think South Australia should be really proud that we've got this safeguarding unit.
Eileen, well, let's talk a bit about restraining people in nursing homes. Another huge topic.
Yep.
And not only restraining physically in chairs or beds, but the use of psychotropic drugs to dull people. What's the prevalence of that, and what can we do about that?
Okay. Look, this is a really touchy area, and it's an excellent segue, Rick, because the thing is with the adult safeguarding unit, they sort of don't tend to work with aged care. I mean, again, because it's state and aged. I mean, adult safeguarding is a state, aged care is federal. Okay, I'm not saying that they don't interact, but I'm just sort of saying there's these lines of demarcation. Now, restrictive practices, it's a really strange term, but what we're meaning is basically where people are physically restrained, so they might have a belt and not allowed to get out of their chair. They might be confined to their bed. They might be in a dementia ward and they haven't got the code and they can't get outside, or they might be isolated by themselves. And all of that is controversial enough, and on top of that you've got the use of drugs to basically keep people quiet. Now, feel free to disagree or take it up with me at afternoon tea. One of the problems with these sorts of practice, well, there's lots of problems, but one of the big reasons that they adopt these practices is there is not enough staff on the floor and they can't cope. So the thing is, somebody might be acting out a bit, and we'll give her this and put her in the corner, and she'll be quiet for a few hours. And it's completely outrageous. So don't get me started. I'll stop there. But I think you get where how I feel about this. But the interesting thing is, from a legal perspective, these practices were going on for a very long time, and then after the Royal Commission, or during the Royal Commission, people were saying, well, gee, this is a really serious problem, and we were seeing lots of testimony from people just sort of saying this is, and in the interim report, which was titled Neglect, this was one area where the commissioner sort of said, something needs to be done about this now. So there was a lot of scurrying around, and it even had Human Rights Watch involved, basically coming in and saying that the way that restrictive practices were being used in Australian aged care were breaches of human rights. Okay, so embarrassing to the government. and appalling when we saw what was going on. Now, what is happening? It's a movable feast. They are trying to tighten the laws up in relation to restrictive practices. And there has been some work, I understand, done in South Australia, which I'm very, very interested in speaking to the people about. But just in relation to the Aged Care Act itself, there's been a number of amendments and proposed amendments. But the problem is you've got people who are wanting to move forward and have a more, respect the rights of the older person. And then you've got a lot of pushback from industry, okay? And I'll just actually, and this came through last night. I couldn't quite. I was quite. I thought, wow, this is kismet. But basically, what is happening, and I will have to just read a little bit. I'm sorry, but I think you'll see why I'm doing it. You've got this, what we call, it's the Aged Care and Other Legislation Amendment, in brackets, Royal Commission Response Number 2 Bill. Okay, so Bill number 2. Now, basically, you've got in this legislation, Section 5411, and what this will do, if it is enacted, is, and I will read this, it'll provide an aged care provider with immunity from civil or criminal liability in relation to a restrictive practice in certain circumstances. Now, why I just find that really disturbing is we're about to have we're going to get a new Aged Care Act, and it's going to be a rights-based, it's going to have a rights-based approach and so on. Okay, we will talk about this after the break. But the thing is, if you have rights and those rights are infringed, then there needs to be a remedy. You should be able to say, I have been unlawfully restrained and, you have injured me, you have hurt me, I've been falsely imprisoned, I've been assaulted, I've been drugged, okay? But what is happening here, again, because I said there's this pushback, what they're trying to say is well, as long as you kind of get, as long as you sort of tick these boxes, you're not going to be liable from a civil point of view or even a criminal point of view, even that person is injured. So that is an incredible protection for providers, okay? Now, if you're working for an aged care organisation, I mean, I understand your arguments, I've heard them, but to take away a person's right to civil and criminal liability, I think really is a step too far, and as you can imagine, there's an enormous amount of pushback. So watch this space, but the argument about restrictive practices has to be resolved, and in my view, if I can say this, it has to be resolved in favour of the older person. And it isn't a matter, I mean, if it's a resource issue, put more resources on the floor. Okay, there are many ways that you can deal with a person who, this expression I don't like it, but I'll use it, who is acting out before you sedate them, if you know what you're doing. Okay, so I'm probably running up against time here, but I'm very concerned about this amendment, and we'll. As I say, a number of people are pushing back. In the break, I can actually let you know about the organisation that is doing a lot of work with the pushback. But I think it's something that we have to be very mindful of, because this could be any of us in a few years, and I think we've got to be, or somebody that we love.
Thanks, Eileen. We are pushing up against time. We do have 10 minutes of questions. There may be a question on that topic as well, and you can explore it a bit further. But in the last 2 or 3 minutes before we go to questions, let me take us to the fourth topic of this first half an hour, which carries on from that question of vulnerability to any sort of abuse, and that's the vulnerability to scams afoot, consumer rights, contracts that catch out the unwary, medical products that don't live up to expectations, some financial products. As a lawyer, I've had to deal with some disastrous outcomes of reverse mortgages. What should we be aware of here? And does the anti-discrimination age legislation help at all? What's our next slide? I'm excited to see.
Yes, I know. It's gone on strike. Hang on.
There we are.
Okay.
Let's talk a bit about consumer rights, taking us up to the question time. So start thinking about those questions.
Okay. Alrighty. When I put this one up, Rick said, "Oh, consumer, are we going to talk about that?" I said, "Yes," because after we talk about the restrictive practices and stuff, we're not going to lighten it up, but I mean, it's sort of there are some quite interesting stories that I could tell in 3 minutes. My gosh, okay, here we go. In a former life, I was actually a property and consumer lawyer. Okay, and so the Australian consumer law still remains particularly of interest to me. And so you've got provisions there, obviously, in relation to misleading or deceptive conduct, unconscionable conduct, unfair contract terms, all of which have special significance as we age, because older people are regarded as a vulnerable group. I'll come back to that word in a minute. As a vulnerable group in relation to the work of the ACCC. Now, the reason that they're using that terminology is because there are a lot of scams which are targeted directly at older people. Okay? And so basically a lot of, the grandparent scam, for example. There is a scam where you'll get a telephone call and it purports to be one of your grandchildren who might be travelling overseas. It's a terrible line, and they're saying, "Oh, help! I'm in jail. I need bail, or something's happened. I've been in an accident." And it's all that high energy. You pick up the phone. It's your child or your grandchild. You think, "Oh my God, they're over there." Now these scams are incredibly sophisticated. Okay. And the thing is, because most of them are based overseas, it's all very well for me to say, "Oh, well, that's misleading or deceptive conduct," or "That's outrageous." But the fact of the matter is, you're never going to get them, or you're rarely going to get them. So the thing is, we've really got to protect ourselves here and be very, very mindful when we are contacted on the telephone, even if it's somebody that we think it's somebody that we love very, very much. Just sort of say, "Well, look, I'll call you back," or find out try to find to verify that this is actually what's going on. Also, too, there's a lot of romance scams. Okay, and the thing is, they're very sophisticated in the fact that they watch people's social media. And they know when people have died, or they realise when people might be lonely, or they see on Facebook that somebody is overseas. So on, they're very, very well informed, and they know their targets. Okay, so watch out for scams. It's all ages. But the thing is with them, we've got all the laws in the world, but the main thing is educate yourself and be very, very careful. Any text message you get, double check it, with your bank and so on. And obviously the Telstra calls, this is the NBN, no way.
This is the ATO.
The ATO, okay, we're coming to arrest you.
Yes, that's right. I always say to them, just hang on to the line. I've just got the Australian Federal Police here with me. We're just tracking you down, and they go away very, very quickly. I have a lot of fun. We have a lot of fun with those. Let me just pause there, Eileen, to say that we actually are now ready for questions. But one other thing too about scams, don't forget the ACCC, the Australian Competition and Consumer Commission, does have a Scam Watch page, which is worth looking at or referring your friends to. And secondly, anytime you start thinking, "Whoops, I think I might have made a mistake," every one of the major banks has a 1800 or 1300 number you can call and get your money back if it's fast enough. That's the quick question. Yep. I'm sorry, Eileen, we've run out of our 30 minutes, so we are now going into 10 minutes of question time. I think we have a mobile microphone somewhere. And if I can ask, if you do have a question on any of those 4 topics, don't forget the other topics are coming after the break, could you please make your questions the fastest questions ever? And we're going to wipe the microphone down between callers. So if you have a question, please, and I hope you're sitting right near the aisle somewhere. That'll make it really easy. So I don't see a hand yet. I see a hand right behind Ruth. Thank you very much. And if you can take your mask off while you're talking, that'll make it easier for us to understand what you're saying.
Okay, I probably should be speaking later. My name's Barry. Okay, I was prejudiced because of my age when I, just before the NDIS came in. So I had gone through 3 appeals with the Centrelink, right, which I won each time. You might be surprised. So I missed out on the ADT, is it called? The legal social security process you go through when you go through an appeal. So I won my first appeal, but they threatened me AAT. The AAT.
The AAT, right?
Yes.
Right,
Yeah. So then
The
the day
Appeals
before
Tribunal. Let me just pause there and say, do you have a specific question rather than a narrative?
Right, okay. Well, as I said, ageism. I have been abused age-wise because when I eventually won, I was 1 year older than the entry date for the NDIS. Right? I have been to the Commissioner for, I'm not too sure who it was now, Equality or whatever.
I might just pause there and say, and come back to the NDIS. If the question is, how does the NDIS tie into ageism? Can I take that as the question?
Okay. Well,
yes, I heard okay. Eileen.
No, look, actually, that is a great question. That is what you've described there is a huge problem because basically, if a person becomes disabled and can come within the NDIS at say 20, 30, 40, 50, whatever, they're in the scheme. If you become disabled after the age of 65, you cannot go under the NDIS. And the problem with that is, of course, that then you haven't got the supports available to you that you would have if you could access the NDIS. And what really makes me cross about that, and thank you for actually, I'll try not to get too cross, but it's incredibly discriminatory. And the fact of the matter is, when in 2013, when this was that age limit was introduced, there was a deliberate carve out from the Age Discrimination Act to allow that to happen. So it is. I really feel for you because the thing is, it is very unfair. There is lobbying for it to cease, but it's taking a long time, and I'm sorry that you've been through that because it really is outrageous.
Let me just move on. We'll take a question behind you, just the gentleman with the other white beard. Everyone's got a white beard here.
Thank you very much. My name's Richard Bruggeman, and I've worked in the area of restrictive practices and disability services for a long time. Mm-hmm. This is a big issue for people who are in our aged care system. Yeah. You can be in hospital, you can be in an aged care service. Your behaviour is really problematic because you're scared out of your brain about this new place you're in, and you get zapped with diazepam. Yeah. You might be prescribed diazepam because the doctor believes clinically that is what you need to deal with something at the time. Two different things. Yeah. And we've got no way of distinguishing between them. There's a group of us old characters who are actually working on this in South Australia, and we're saying that there needs to be some external eyes looking at and authorising the process whereby these decisions are made. It should not be left to the decision makers in hospitals. And my question is there anybody in the audience that would like to join us? Because I've got my cards here. I'm happy to share the information with you.
I would love to join you.
Plug.
No, actually, please, I would love to hear more about your work, but also I'm actually involved at the moment in a project for the Australian Association of Gerontology on legislating for enforceable human rights in Australia. And restrictive practices is obviously going to be front and centre in relation to that. So I would love to hear more about the work that you're doing. Thank you.
Can I just say that we are right on time in terms of having a break, because I'm going to suggest we come back at exactly 5 minutes past 3, and there will be some opportunity for you to actually ask Eileen some questions rather than having the questions to the floor. So by the time we head out, and by the time we head back in, we're going to start talking again at 3:05. But thank you for all being so expeditious and coming straight back in. I appreciate that. We're right on time, and we've had some feedback that Eileen's voice is sometimes a little soft. So what we're going to be doing is having both of us now talk to the little remote right in front of our faces, Eileen. So you'll be easy to hear. So we've got another 4 topics in this next 30 minutes, plus then we'll have 10 minutes of questions at the end. So our first question is about housing, accommodation and care. In fact, I had a couple of comments about this subject during our afternoon tea just then. As we age and as the family grows up and as we're in a big family home and thinking of downsizing, so we start considering our next options and the pitfalls begin to manifest themselves. There's retirement villages legislation, there's protection for renters, but a range of options involving contracts for licences to occupy or outright purchase. There are independent living facilities, aged care facilities, nursing home options, but each has its own contractual obligations that are as confusing as there are options available. Does the law help here, or does it hinder? Eileen.
No, it's definitely. Is that better now? Yep. Okay. Look, it's the law is probably a bit of a hindrance in this area, but we'll take it through step by step. A few years ago, a group of us wrote a report on security of tenure for older people in Western Australia. And the reason for that was there seems to be a perception that older people have their own home. Many, obviously many do, and that's a very, very good thing. But a lot of older people do, and that's a very, very good thing. But the thing was, what is often forgotten is that there are many older people who are in much more marginal forms of accommodation, or they go into retirement accommodation where they think they are looking at a secure, affordable retirement, and that in fact isn't the case. So I've just put up. Oh, hang on. Let's come back. This thing has a mind of its own, actually. Oops. There we go. So. Yep. So the main thing is the real interest with housing is, of course, that housing is just so fundamental to people's health and well-being, and so basically, where the law is, where the law can impact the most, the older people who are in their own home are really in the box seat. Okay. Now, I'm not saying that there aren't issues with that, because often older people with a significant asset that may have been a very modest home, 30, 40 years ago, and now is worth a couple of $1 million, can become a target for financial elder abuse, which I've mentioned before, or an expectation, what we call inheritance impatience, where younger members of the family who are trying to get on the housing ladder sort of say, oh, well, you've got this asset. So it can be problematic. The other thing many people think about doing is perhaps downsizing. So the family have grown up, you're rattling around in this big house that needs maintenance. Some of the problems though with downsizing is it's just so very, very expensive to downsize, and often it really isn't. It may not be worth all the effort in relation to the cost, the stamp duty, the moving costs, where the furniture is going to fit in and so on. So the taxation laws and indeed the property laws often tend to conspire against people successfully downsizing. I'm not saying it can't be done, but sometimes the laws conspire. One of the really interesting areas, and I will be very brief with this, but it is very, very important, is the increasing number of older people who are renting. And of course, if you are older, if you're on a fixed income, and the increase in the cost of renting over the last few years has been phenomenal, and the impact of that is, of course, that we're seeing, with the bottom one there, we're seeing a rise in the number of older people who are becoming homeless. Now, unfortunately, there is nothing in the residential tenancies legislation which protects older renters, or indeed vulnerable renters at all. Okay. In some jurisdictions, there is such protections, but in Australia and in South Australia, there is not. So if you can't pay the rent, you're out. But what we're seeing is older people who are reluctant to ask for repairs or to ask for modifications in the home to make their life easier as they age, because they're frightened that they may not get another. They might be asked to leave. Now, with retirement villages, we could have had a whole seminar on this. They can be extreme. The first thing in relation to them is the contract. The contract issue is a nightmare. There is no standard form contract in relation to retirement villages, and you've got to. So if you're shopping around, if you like, and you've got all these different contracts, and I struggle with some of them, and I've been doing contract stuff for a long time. But I struggle with some of them. Also, too, one of the myths, and I'm being cynical again, but here we go. One of the myths is in relation to consumer protection, and this is built into the retirement villages legislation around the country. Is you've got disclosure. We disclose everything to you, and therefore you're a fully informed consumer. And you can make a decision, an informed decision about what your accommodation. That is rubbish. Okay, if you're presented with all this paper, it is and these disclosure, it can be very, very difficult to work through without legal advice. And Rick and I and our colleagues would be delighted if if everybody lined up and saw lawyers. But the bottom line is, if I can say this, if you are seeking legal advice about a retirement village contract, just make sure that that it isn't necessarily a solicitor who is being referred to, that is referring you by the retirement village itself. Okay, so no, trust me. But the other thing too is make sure that they have had experience dealing with retirement village contracts, because as I mentioned, they're very, very complex, and there are potential pitfalls everywhere. So just briefly, things like if you decide you don't like it there and you're wanting to leave, things like exit fees, and and it may be that you lose money on your investment in the retirement village, and you may not be able to get the kind of property that you want, when you leave, because of these fee structures. So you've got to be very, very careful in relation to these contracts. Indeed, the ACCC at one stage was looking at, or has been looking at, retirement village contracts from the perspective of the unfair contract terms legislation. They've wrapped a couple across the knuckles, and they've actually had a few provisions changed, but there hasn't been a major action as yet. Manufactured homes are a particular interest of mine, and I will be quick here, Rick. I can look at your watch. But the reason I mention this is they are often, they are marketed towards people who are looking for a lower, a more economical retirement option, where you do have that sense of community. So on the face of it, they're very attractive. The problem is the way it is legally structured. What you are doing is you might spend a considerable amount of money on a manufactured home, but you don't own the land on which you park it. Okay, so basically what will happen is you've got an asset of sorts, being the home, but you are leasing the land underneath that home. And if the park owner decides that they want to sell the land because it's now very valuable, you are going to have to leave. And it's very, very problematic. Now, the laws have been tightened up somewhat in the last few years, just in respect of the amount of time that you get to where you can leave. Okay, so so it can be, you get a longer period of notice, if you like. But the fact of the matter is, you are only there renting somebody else's land, and that time is going to run out. So be very careful if you're looking at manufactured home living, and that includes some of your more glam lifestyle villages. Not all of them, some of them are okay, but just be very careful of the product that you're looking at. Aged care we will get onto again later, so I might just skip over that. We've talked about it a little bit. And homelessness. The rate of homelessness of older people in Australia is increasing, particularly older women. The reason for this is basically being in and out of the workforce, looking after family, often looking after older relatives, perhaps. Older women may not have been able to accumulate a lot of superannuation because they either weren't working or it simply wasn't around in those days. And what happens is, if something happens in mid to later life, so there's sudden death of a spouse, a divorce, illness and so on, there is no wriggle room for a lot of older people, particularly older women. So I just wanted to alert you to that, because it's often something which flies under the radar, and it's becoming a very, very concerning social problem. So I just thought I would, and the law can't help. The law is useless in that respect.
That's a segue for me, isn't it? The law is useless.
Yes,
Thanks, Eileen. Let me make an observation that I'll come back and ask you to address the idea of living with family. The observation I make is, having looked at a dozen or so retirement village type contracts in the last dozen or so years, I recognise just how many variations and permutations of accommodation and purchase price and licence to occupy, etc. there are. It seems that every one I look at is different to the next one. One myth that I heard, or something I heard once from someone who said, they told me not to worry about all these things here. That was all part of the legal requirements. If you don't understand it, you don't understand it. It's their obligation to make sure you do. And the number of times I've written to these clowns and said, sometimes you might just need to make these things a little easier to understand. That's one thing. The other thing I want to mention too is about the Australian Financial Complaints Authority. You can go to the AFCA if you think in some way that your financial dealings with your retirement village or your licence to occupy have caused you some financial grief. The Australian Financial Complaints Authority has a wonderful website you can have a look at. And finally, as Eileen said, typically you can't sign one of those without legal advice. And the number of people who said to me, I went to see the lawyer, they explained a whole bunch of things to me I didn't understand, but I signed it anyway. Could you please emphasise that if you are going to an independent advisor, and there are now some firms that focus and specialise in aged care homes, go to the Law Society and say, can you recommend one or two or three names of firms that you can assist you with those sorts of contracts? And if you don't like the contract, go somewhere else. Let's talk about family, living with family. Eileen, what's the issue there?
Okay. This thing doesn't like me.
Point it towards the...
Yeah,
Perhaps point it to the computer.
it's working. Yes, sorry. There we go.
There's the family.
Thank you. There we go. There's a family. Okay, thank you.
So what are the pitfalls of living with a family, Eileen?
Okay, this is a loaded one, and it's very, very interesting from a legal perspective. Basically, we all think, as we get older, wouldn't it be wonderful to live with family? And well, maybe not. But age with our family around us, as long as we all get on. One of the problems with this, one of the many problems with this is it's almost like a legal badlands. And an older person who enters into an arrangement, which these what they call assets for care arrangements, which I'll describe in a moment, actually puts themselves in quite a difficult legal position. Okay, so basically, when we talk about assets for care, it's any kind of arrangement where the older person may sell the home, give some money to the adult child to live with them for the rest of their lives, build a granny flat in the backyard, build an extension in the house, or simply just move in. Okay, but the thing is, there's been an exchange of some kind of consideration for care, and often these arrangements work very, very well. Okay, and which is marvellous. The problem is, from a legal perspective, when they go wrong, they go very wrong. First of all, because it's family, and we all love each other, don't we? We all trust our families. They're rarely reduced to writing. Okay, so and often these sorts of transactions will happen like there'll have been, somebody will be diagnosed with an illness, or somebody's had a fall, or there's been a passing in the family. And they're often done in times of crisis. Oh, come and live with us. We'll look after you. Sell the house. It's all too much, and so on. People rarely reduce this to writing, and then when there is a dispute, that one person will say, "Oh, well, this was a gift," and the other person would say, "No, it was for the care," and somebody else will say, "Oh, well, this isn't what we agreed to," etc. Also, too, nobody actually thinks about what will happen when it goes wrong. So when there is when we need an escape clause, there really isn't one. Okay, now why am I saying the legal position is so dire? If these things don't work out, and it may not be because you suddenly discover that your kids are ghastly or something, it can be something like the adult child may divorce and they have to sell the house as a result of the divorce, or again, somebody could become ill. There's many reasons that these things fail, but the bottom line is, if the older person has not got themselves on the title to the land, and again, like a contract, most people don't, they are not recognised by the law as really having an interest in that land. Okay, they've handed over this money, but they're not actually on the certificate of title to that land. So how do you get your money back? And the problem there is you've got to actually rely on all these rather Dickensian, what we call equitable doctrines. So to go to the court and sort of say, well, look, there has to be a constructive trust, or, there's, it's a failed joint venture, or there's an estoppel. It's all these, again, Dickens, think Bleak House, So basically, and with equitable remedies, you have to go to a superior court. So it's lengthy, it's expensive, it's stressful, and who wants to take their family to court? Okay, so in a time of increasing house prices, nobody wants to go into aged care anymore for obvious reasons. The idea of living with family sounds fantastic, but again, really think through. So basically, get it in writing. Think about the worst case scenario, what will happen then, and how you can get your funds back. Because if it goes wrong, you won't have any money to go and buy something else, and you'll fall into the problems that we talked about before. The renting issue, which can be so difficult, or indeed I've seen too many of these cases where older people have that I'm not taking my family on in court, no way, and they're living with this couch surfing, or they're homeless. So whilst it sounds idyllic, be very, very careful from a legal point of view if you're anticipating this.
There's an old adage, Eileen, that says when someone says to you, "Oh, we're friends or we're family, therefore we don't need an agreement," you turn that around and say, "We are friends and we are family, so we do need an agreement." It should never be said that you don't need an agreement, particularly with family and friends. Eileen, I do want to move us on because we have two more topics to get through in the next 15 minutes. And this next one, we can spend again the whole afternoon, the aged care system. Now, we're all aware of the system, which has been set up in the last decade or so by the federal government to keep people in their own homes as long as possible. My wife, dealing with her late-aged father, my own story in the last 12 months dealing with my late father, we're very, very familiar with this aged care system. But the Aged Care Royal Commission had a lot to say about its deficiencies and called for a rights-based approach. So we now have legislation for aged care. We heard before about the tie-in with the NDIS, or the lack thereof, and a range of amendments to improve the system. How does one navigate this minefield?
It is a minefield indeed. I'll just pick, again, could be the whole afternoon, but I'll just pick up on your point, Rick, in relation to the care with your in-laws and your dad in the home. Often when we're talking about aged care, we focus very much on residential aged care because that was where a lot of the really horrific stuff in the Royal Commission came out. But what is often easy to overlook is that you've got, if we actually look at the numbers in residential aged care, there's far more people who are involved in the in-home care scheme. Okay, now obviously this is where you've got people, you get a package and they're coming into your home. Now the first thing is actually getting that package, so that organising the assessment and then being, classified into 1, 2, 3 and 4, level 4 being the highest level of need. Now, you recall I mentioned earlier on about the interim report in the Royal Commission that was titled, as I said, it was titled Neglect. One of the, one of those three issues, one of them was restrictive practices. The second one was in relation to the number of home care packages or the lack of home care packages, because what's happening is, on the face of it, we've got this terrific system where you can get this care in the home and you can be looked after and you can stay at home as long as you need to. But the fact of the matter is there is a huge wait. So it can take
9 months in both of our cases.
About 9 months, yep. And I mean, there have been people who die on waiting to get one of these packages. So more money has been pumped into that, but I mean, again, it's not going to make a huge dent in the number of people who are waiting. And then, of course, when you can't cope anymore, it may have to be residential aged care. So getting yourself assessed in the first place, and even then, you may not necessarily, get that in-home assistance that we're looking for. Now, the other, sorry, I just haven't been derelict here.
Give it a bit of a whirl.
I'm actually going to, if I can do a bit of self promotion with just briefly, because you seem like a really engaged audience, and some of the conversations I'd really love to follow up with many of you. I mentioned I'm working on this project with the AAG, the Australian Association of Gerontology, and what it's based on is basically with the final report of the Royal Commission. The main recommendation was that we were going to have a new Aged Care Act, and it was going to be a rights-based act. Okay, so the focus was going to be very much on the rights of the older person being respected in that. Now, what that means at the moment is rather opaque, and they're hammering it out in Canberra as we speak. What the project I'm working on involves is basically, identifying, human rights relevant to older people, in aged care, and how do we enforce them? How do we get them into the law? And indeed, then how do we get a remedy, from that? Okay, so again, rights, it's remedy, alrighty, which is why I was so disturbed when the restrictive that in relation to that restrictive practices amendment, where they're taking away civil and criminal liability, that cannot sit, in my view, with a human rights-based act. So I just sort of wanted to put that out there, because the whole aged care issue, we're going to have a brand new act. And so the whole landscape is going to change. So the 1997 legislation, which is basically, can I say this? We're winding up, so I'll let my hair down a bit.
Let your hair down.
Yeah, the 1997 Act was basically a licence to print money for private providers. There, I've said it, okay? And hopefully this will turn around, but there is a lot of pushback in relation to how far this rights-based approach is going to go. So I think we've got to be very mindful of that. So if any of you are interested in that project, or there are instances that you'd like to draw to our attention that we could, that could inform our report, I'd welcome any input from you.
Okay, we're down to our last 5 minutes, and we are getting to the end of our afternoon, which is very appropriate for us to go to the end of life considerations. So let's look at this for the last 5 minutes, then we'll have 10 minutes of questions. Thinking about enduring powers of attorney, advanced care directives, voluntary assisted dying options. What are the important considerations that empower us to take control of that uncertain future that faces all of us?
Okay, all of the above. But look, basically, I'll just speak briefly about enduring powers of attorney and advanced care directives, because often they tended to be bunched together, and they deal with two very different areas. Look, with an enduring power of attorney, I really can't emphasise enough for somebody of any age to get an EPOA in place, because what it will do is it empowers another person to look after your interests if you lose capacity. Okay, so whether that be because of age, dementia, an accident, but an EPOA is only relevant to legal and financial matters. Okay. Okay, so what do we do with that? Think very carefully about who you make your EPOA, or sorry, who you make, you give that power to, because it is an enormous power. It's effectively handing over to another person their right to your bank accounts, your land, your property, etc. Okay, you do have to register EPOAs in relation to land. So if they're going to sell your house, you're going to have to register it, and also in relation to shares, it needs to be registered. So be very careful about the person that you appoint, and if you're going to appoint two people and they have to confer with each other, that's probably even better. So the big questions are, what powers do you want them to have, and who do you want to give the powers to? Now, with advanced care directives, this is where you're talking about, decisions in relation to health, end of life, although there's a bit of a, we'll talk about that in a moment, healthcare, living arrangements and personal matters. Now, when I teach my ageing in the law unit, I get my students to fill out an advanced care directive, and it really makes them think about, well, if something happened and I really wasn't in control anymore, what would I want to happen, say, in relation to my health? And see, the default position is very often, oh, well, I don't want to be a burden, therefore I'll turn off my life support or something like that, something very, very simplistic. But when you actually think about it, when you actually think about it, there are so many permutations that can happen in these situations. Okay, so in South Australia again, there's a fantastic resource. You can actually download it off the net. Here we are saying go and see a lawyer, but you can download this off the net, and it gives you all these things that you can actually think about when you're getting this advanced health, this advanced care directive together. So they're the main two, the EPOA and the advanced care directive, just to make sure that your wishes are honoured if you're in a position where you can no longer look after your own affairs, whether they be legal, financial, health or personal. And Rick briefly mentioned the voluntary assisted dying. Where the link with the advanced care directives is, now look, voluntary assisted dying is, as we know, is very, very controversial, and the law has recently been passed or it was passed in 2021 in South Australia, but it isn't, what's the word I'm looking for?
It's not operative yet.
It's not operative yet. Yes, it's been a long afternoon. Sorry, everybody. But basically, there's a lot of hoops to jump through. But what I wanted to emphasise is, don't try and use your advanced care directive to say, I want to end my life or whatever through this scheme, because that's not going to work. Okay, you've got to if you're going to utilise voluntary assisted dying, there's a number of hoops which you have to jump through. I'll just briefly mention a few. You have to be 18 years or older, Australian citizen, live in South Australia or have lived in South Australia for 12 months. You have to have decision-making capacity. Now, when we're speaking about that, it has to be decision-making capacity in this particular context. So you've got to be able to understand that, that you are agreeing to voluntary assisted dying. You're probably all quite familiar with the fact that, with the idea of capacity, you can have capacity to have, do basic contractual things, but not, complex business transactions. There's capacity, there's a range, okay? So in this one, the decision-making capacity has to be, you understand that this is what you're signing up for. You have to have a disease, illness, which is incurable, advanced or progressive, and it will cause death within 6 months or within 12 months if it's a neurodegenerative condition. It's a long afternoon, and it causes suffering that cannot be relieved in a manner that you consider tolerable. And also, you have to establish that you're acting freely without coercion. So there are a lot of hoops to jump through. The only thing we can, that I suppose I can make a comment on, is there has been, and there's strong arguments on both sides in relation to this, and but the thing is, one of the big concerns is that people are just going to, lots and lots of people are going to take advantage of this, and they're, or they're going to feel pressured to do it, so they don't want to be a burden on their family and so on. In Victoria, for example, where voluntary assisted dying has been operative for quite some time, we're not talking huge numbers at all. So it's not. So basically, you know, it's a people are thinking this through and accepting that this is what they want as an individual in their situation. So there's not hundreds, thousands of people taking advantage of this. So I don't think we need to be afraid of that. Also, too, South Australia's been very careful. They've actually set up a number of committees which are really making sure that this is, you know, that everything is nailed down for when this becomes available. So I don't think it's something that we need to be scared about, but it is something. It's there. Hopefully, none of us will have to consider, us or our loved ones have to consider it, but it is there. So it's worth thinking about.
Thanks, Eileen. Let me make a couple of comments and then we'll go to questions. The first comment is on the capacity. It's a famous case about a chap who was getting married for the second time very late in life, and he married, and as you would probably know, a marriage invalidates every previous will you've made, and he then made another will in favour of this very young woman, extremely young woman, and then he died. And the question was the...
Of natural causes?
Yeah, of natural causes. The question then was the second will, or the will to her, valid? And of course, as Eileen just said, it's actually a very high bar. And every lawyer is trained to not take instructions from someone that you don't believe has the capacity to make the will. And ultimately, the court then said, no, that second will was invalid because he didn't have the capacity. The question was then, did he have the capacity, 6 months earlier to get married? And the answer was, yes, he did. So your capacity to get married is actually a lot lower than your capacity to make a will. The nice thing about that was the second will was then invalid in any event. Well, it was invalid, and the marriage said it actually had invalidated his previous will. Ultimately, he died intestate, and they passed all the land and other matters in accordance with the legislation, which actually went back to his previous children. So it was kind of a nice outcome in the end. But leaving that to one side, in the last 6 months, 2 of my cousins in their 70s have both died, and in both instances had never made a will. I am just in absolute despair of that, so I'm not going to ask anyone to identify if you haven't done that. Could you please make a will? And as you do, by going to an independent lawyer somewhere, get your power of attorney, enduring power of attorney done, and your advance care directive. It's pretty straightforward. Now, again, I'm going to be slightly naughty here and say, can I suggest that you go to an independent lawyer and you don't go to the public trustee or a trustee company, and you name someone who's a trusted individual in your family as your executor and trustee. The reason I say that is because then when you go to a lawyer to tie things up, things are going to be fairly inexpensive. If you've got a lot of money and a lot of property, the trustee companies will take a percentage of that. I had a quick check last night, under $500,000, they're around about 3 or 4 or 5%, and if it's over $600,000, it's more than 1%. So if you've got $1 million property and you're the last person and the trustee company or the public trustee is taking that, you're going to be shelling out at least $10,000 in just those fees in terms of their percentage as opposed to the actual work they do, which is on top of that. So my plea would be, don't give it to a trustee company or the public trustee. Give your executor trusteeship to someone who's a trusted family member or a spouse. Now, that's my little comment. We've actually got about another 10 minutes before we have to finish this afternoon. So Jade will run around with the microphone. I see a hand immediately halfway up the steps there. She will sprint up there because we're running out of time. I see a lot of male hands coming up. I want to see some female hands coming up as well at some point. Okay, there we go. Nice, loud voice.
In the first session, you had reverse mortgages on the screen but didn't address them. I know of people that have taken out a reverse mortgage, and then when they wanted to go into a retirement village, found that when they went to sell their house and the money got taken back by the bank, they were in a bit of trouble. Whereas if they'd actually gone straight to a retirement village, they probably would have had money left over to do what they wanted to do. So what would you like to tell me what you think of reverse mortgages, please?
Well, I might actually throw to Rick there, because we were actually chatting about this yesterday and you had quite an interesting example.
Look, let me just answer that very quickly, that there are a number of people for whom reverse mortgages may work, but there's a lot of people for whom reverse mortgages don't. And my advice simply would be, if you're going to a reverse mortgage, go and see a lawyer who would advise exactly what those outcomes are going to be for your situation, and that lawyer should be a lawyer who's not linked to the reverse mortgagee, the companies that's encouraging you to do that. A lot of people actually do like the idea of so-called freeing up the equity in their home, but typically the interest rates are pretty burdensome, and if you want to get out of the contract, there's often a break fee. I had a big victory about 3 years ago in relation to a reverse mortgage, where the Australian Financial Complaints Authority assisted me in going back to say that the interpretation that they were applying in that reverse mortgage was actually flawed, and we had a win, but those wins are few and far between. My advice is, if you simply want to borrow some money, don't borrow it on the equity in your home, because that would just kind of burden you and your loved ones when, as the years roll by, you start seeing the value of your home diminish dramatically. But as I say, for some people they might work. Get independent legal advice. I see a hand right down here, but if you're walking down, Jade, and there's a hand on the way, we might grab one. Okay, looks like you're going to leap down and take the question down here. Yeah.
Good to see you again, Rick. Topic for a future seminar, which we haven't touched on today, is refundable accommodation deposits, commonly known as the RAD. Now, this is a huge issue. We touched on retirement villages, but the paperwork and the concerns that not only the elderly have and their families, who have to give a very expensive RAD and fill out extensive paperwork to either Centrelink or Veteran Affairs, is absolutely horrendous. And it needs to be publicly educated. We need to lobby the Commonwealth Government to make sure that this process is easier. So my question really is, can we have a future seminar just purely dedicated to the RAD?
Yeah, the answer is yes.
No, I mean, as long as you promise when you come along you can do the maths, because I actually did I did a course in Sydney with Richard McCullough, and he took us right through RAD, and then we had to do a lot of the calculations in relation to it to really bring home exactly those points that you've made. So I'm happy. We're happy to do the seminar if you guys will do the maths.
We have time for a question here in the front row. Thanks, Jade. Let me just say, in relation to retirement village contracts, there are lots and lots of permutations where you, when the place is sold, you get a percentage of that sale price. There are others where, in fact, you buy them at a very low price, but all you're doing is getting a licence to occupy, and all of your money dissolves after 4 to 5 years. So all I'm saying is, when you go into those options, there's as many options and contracts as there are permutations on this earth, and all I'd ask, though it sounds like an advertisement for a legal practice, is you get independent legal advice so you know exactly what it is that you're signing up for, and don't think that everything's exactly the same. Everyone will have to be suited to your purposes. Yes, we'll take the question here.
Thank you.
Could you put the microphone right up to your mouth?
Sorry.
That's it.
Regarding voluntary assisted dying, it would appear to me that it is possible to have dementia included as a neurodegenerative condition, and that is a condition that many of us see among our relatives and friends, and we regard it with great horror. And also our junior relatives also have to put up with some really awful things as a result of dementia. I wonder, is it possible to make an advanced care directive within the 12 months, just as the early signs of dementia are there, which still allow you to be able to make decisions of this nature, and say that if I am below a certain score on the dementia chart, then I wish to have VAD?
It's the great question. Look, the thing with dementia is, if somebody is experiencing dementia when they haven't got the decision-making capacity to opt for voluntary assisted dying, they won't be able to do it. If a person is experiencing like the early stages of dementia, but they are still capable of making that decision, yes, but the thing is, you would have to have the other factors in the sense that you've got the advanced, you've got the disease and you're in pain and that it can't be alleviated. Simply having, and actually this has been one of the criticisms, this was one of the things that people were worried about with voluntary assisted dying, because they said, oh, well, somebody could say, well, look, I have dementia and it's going to be terrible and therefore I want to go before it gets too bad. No, that's not going to, that won't come within the legislation. Thanks.
Okay, we have a question over to my right. Where you go, sir.
Hello there. In regard to manufactured homes, why can't the government legislate to have a minimum lease period?
Sorry, I just didn't catch
Just repeat that question. To do with manufactured homes.
Why can't the government legislate for a minimum lease period?
A minimum lease period.
There can be a minimum lease period, but the fact of the matter is the leases are never that long. One of the problems in Australia with renting generally, and with manufactured homes, you're renting the land, is that the tenure, like the period that you're in there for, is very limited. Okay, so even if you might have like 6 or 12 months is the average, can be the average. With manufactured homes, like for example, in some jurisdictions you can have 5 years, but if the land is sold, then it can still be problematic, and certainly after that 5 years you have to go. Where we need to look at, in my view, is actually look at what they're doing in the United States. I mean, we tend to be very dismissive of trailer parks in the United States, but the thing is, what is happening over there is they're actually introducing these things called community land trusts. So the people actually invest in the land itself as a group, and therefore they can't be kicked off. Or so I can't see why we can't be doing that here with manufactured homes, and similarly with councils, why tracts of council land can't be put aside for more manufactured home parks, because we need more lower cost community retirement options, and at the moment the law doesn't support those people.
Okay, we'll take one last very short question and a very concise answer.
Oh, sorry.
I don't mean that to be rude. I mean, just we've got 60 seconds, so it's going to have to be a very short question, a very short answer.
We're seeing a different side of Rick this afternoon.
Rick, I just want to ask, I'm interested in the responsibility of councils for the surfaces on which we walk around. Today I've seen a number of people stumble because of unsteady surfaces. And I'm interested, if we can't do it today, another time, to talk about the responsibilities that councils have for the footpaths and other things on which we stumble or fall and people are injured.
Let me give a long answer here. Just kidding. Let me give a very short answer, David, after that phone is answered. The responsibility of councils, of course, is to owe a duty of care to people who are walking on those footpaths, and in fact the same way in which the councils typically are responsible also for the roads on which we drive, and they have a responsibility to fill in potholes, because every now and again a cycle or someone will walk into that pothole. All you can do is ring them immediately, because they satisfy that duty of care by having a remediation list. They do that because otherwise they'd be responsible for every last trip where people do fall over. Now, if it's an egregious thing that anyone, walking along would have thought, this is just outrageous, this has not been fixed, then there might be liability straight up and down. But for the most part, all you've got to do is, as a council, have a remediation list on which there might be 400 things you're going to be tackling. You will have a remediation list where people will set priorities in terms of what the urgency is. And so long as you're meeting that remediation list, you've satisfied the duty of care, because we can't expect every council to immediately go and repair every last thing within seconds of it being revealed. So the councils are not usually found liable. And in some respects, that's good, because our rates rates remain low. On the other hand, if you've fallen over and hurt yourself, you can try it out, but the chances of actually winning, unless it's an egregious breach, are not very good. The best answer is keep a lookout. And keep a lookout with aged care issues too. I'm going to hand back to Ruth now to wrap up the afternoon.
I'm wondering if I might hand over my job to Rick. He's done such a marvellous job today. Before I thank them on your behalf, I just would like to extend a vote of thanks to my wonderful team, Jade, who's got much fitter this afternoon, but also to Sarah and Anne, because putting these seminars together, it takes a lot of organisation, and I do thank you very much, team. That's fantastic. We will be having another... Thank you. We'll definitely have another session on these topics, and thank you to the questioner who suggested that one of the topics already, but we will do that. If not next year, certainly the year after, because there'll be some new legislation, I'm sure, to talk about. One thing to say is it's been an absolutely wonderful session. So many gems of information. Don't forget that you can go online to revisit what has been said. I just want to say at the very end, when you visit your lawyer, it's always handy if you take a bottle of wine. As a consequence of that, I'm going to give these two legal minds a bottle of wine by way of thanks for what they've done today. Please join me in thanking them again. We'll see you in September for the next Successful Ageing seminar. Good trip home.